Oh, you have? Okay.
I mean, you made that request. I don't always have a hearing on them, depending on what the allegations are. It's a high bond, but I set a bond. So bond has been set in his case. So I'm going to reset it for an updated pre-sentence report. And if there's any other issue, get with Ms. Malfino, Mr. Coleman, if you'll make sure Ms. Malfino knows kind of what went on this morning. Let her check that affidavit. If anything changes, y'all let me know, but I set a bond.
How much is it going to cost?
200. Thank you, Kelly.
So he's not doing that?
No, ma'am, we're good. Mr. Kimler, you've got Gabriel Smith. So was this a re-indictment?
Yes, ma'am, that's what I was going to tell you.
Is it going to show up here? It says it was.
Let me show you. This is what he filed in the original case, and then they re-indicted the case and the bond, switched over to that one.
So can we get this to show up now in the original? I mean, in the new case?
I can ask him to either redo it, or I can, yes, ma'am, I can get it in there.
Okay.
I will do that.
Okay, let's see. You are Gabrielle Smith? Stand up, please. And this is cause number 25, DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct?
Yes.
Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now as far as trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
Yes, sir. Just here. Ready to get my charges, I guess, decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Yes. Yeah, that 23D 60 or 1030.
Look, such a big copy of them that I bought myself. Okay, let's see.
Every time something at least a petty thing.
So, it looks like okay, there was back in February of 2024, there was a bond forfeiture, and so the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She then entered a plea, Your Honor. And
Entered-
said PSI bond.
I did
That plea
at
was
one.
then rejected by the court.
Okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess.
for a PSI, I reduced it to 1,000. And then appears as though in February of this year. I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out. Okay. And then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000, so I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report,
Court revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you rejected that.
right, and several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at 40,000 on a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge, but as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. Involved a vehicle. I think the officer had leaned into it, and then the vehicle went into motion.
Well, how did the vehicle go into motion?
Well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
He scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about, yeah, I suppose.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. Motion's denied.
Okay, we've got a speedy trial, I guess, so we need to try.
We're in the 252nd, everything's speedy.
All right,
It will be placed, I mean, it wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
Well,
the,
I guess if this court has rejected the plea offer on the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
You can take 8.
Take 8. You want me to do a rejection?
And still be in.
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Goodness gracious. Mr. Matusko, you've got Xavier and Garner. 6 cases. Oh, I don't have, hold on, let me recall that in just a second. Do you have some stuff coming through on Garner? I've got a registration, but I don't have anything else. All right.
Then I'll need to put the title judge up in the period.
Okay, that's okay. I'll hold it for just a second. Thank you. That's gonna be a good one. Get rid of 6 cases. Mr. Parker, you've got Jacoby Judge. Okay, again, you're Gabrielle Smith. And Ms. Smith, and cause number 25, DCCR 0979. You're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
The judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Muffin, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here. If any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison up to 99 years or life in prison. Do you understand?
Yes, ma'am.
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have two sequenced, it would make you habitual. Do you understand?
If she has one, it would boost her up to first.
Yes, sorry. So if you have
Still
one,
not understanding what they mean.
okay, so listen very carefully. You have several felony convictions out of Louisiana. Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life if there's one prior conviction. You understand? Answer out loud. So
Yes, ma'am.
okay. If there's two prior felony convictions that happened, not all of the, I know there were several that happened at the same time, right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are two that happened at different times, then it means you could be considered a habitual offender here in Texas. And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count one, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years and what your possible consequences are if you go to trial. Do you understand all of that? Okay, and do you want to reject that offer and have your case set for trial?
Yeah, I want to reject.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes to trial. So it's not we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I haven't, so I can't think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for.
You have to decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If y'all do it again, you'll have to do it again. Okay?
That courtroom session had just about everything packed into it. Bond disputes, a rejected plea, and one very sharp reality check for a defendant staring down life-changing consequences. Presiding over it all was Judge Raquel West, who handled the hearing with her trademark balance of calm authority, precise legal reasoning, and straight talk that left zero room for confusion. The spotlight of the day was on Gabrielle Smith. She's been sitting in jail for a year on a second-degree felony charge of assaulting a peace officer, and her attorney made a push to slash the bond from $40,000. Judge West, however, wasn't ready to be swayed. She revisited the history of the case in full detail, reminding the courtroom that she had once lowered the bond to $1,000 during plea talks. But after reviewing Smith's record out of Louisiana, 9 prior felonies, multiple misdemeanors, and even a probation revocation, the bond was raised right back to $40,000. That background set the tone. This wasn't just another defendant asking for a break. This was someone with a long paper trail of serious offenses. Judge West then dug into the probable cause affidavit itself, walking through the details that included allegations Smith had scratched an officer and that a moving vehicle played a role in the incident. Even with those gray areas, she was firm that the combination of Smith's history and the seriousness of the charge outweighed any argument for lowering bond. The motion was denied without hesitation. From there, the hearing shifted into sentencing exposure and plea discussions, and this is where Judge West's clarity really came to life. She explained the punishment ranges line by line, breaking down exactly how prior convictions could change everything. With one prior felony, the sentencing range could leap to first-degree levels, 5 years to life. With 2 sequential priors, Smith could be labeled a habitual offender, meaning a mandatory 25 years to life behind bars. West didn't just throw numbers at Smith. She laid out the risks with precision, making sure there was no doubt about the gravity of her choices. The state had put an 8-year plea deal on the table. For someone with her history, Judge West made it crystal clear that this was more than just an offer. It was a chance. Smith, however, didn't commit on the spot, asking for a week to think it over. Judge West granted the extension but drew a hard line. This wasn't to be mistaken for endless negotiations. Once a case goes on my trial docket, it goes to trial, she said. That blunt warning left no wiggle room and set the stakes in stone. You could feel the tension as the courtroom absorbed what was said. There was no shouting, no theatrics, just a measured walkthrough of law, consequences, and options. And that's exactly what made the hearing so powerful. Judge West balanced empathy for someone who's been locked up for a year with the seriousness of her criminal history, giving Smith the respect of transparency while holding her fully accountable. At the end of the day, it wasn't a flashy hearing, but it was a textbook example of judicial communication done right. Smith walked out not just with time to decide on a deal, but with a crystal clear understanding of exactly what she was risking if she gambled on trial. And that's the kind of clarity that prevents surprises later. If you found this breakdown insightful, don't forget to subscribe, hit the bell, and drop your thoughts in the comments. I read every one of them.